Magandang umaga sa ating lahat at sa ating mga kaibigan na nanonood sa anumang sulok ng mundo. Ako po si Pat Teves, isang mag-aaral ng medisina at ako po ang magpapadaloy ng webinar na pinangunahan ng CARMMA o ng Campaign Against the Return of the Marcoses and Martial Law. Ano nga ba ang CARMMA? Ang CARMMA ay isang kampanya upang mapigilan ang pagpapanumbalik ng pamilyang Marcos sa panunungkulan sa gobyerno at upang mapigilan ang martial law. So bale, tax season na naman nga po mga kababayan. Kaya marami pong mga establishment, kumpanya, institusyon at mga individual ang naghahabol sa itinakdang deadline ngayong araw ng Bureau of Internal Revenue o BIR na mag-file ng kani-kanilang mga income tax returns at para magbayad ng buwis. Madalas nga po kung sino pa ang mga may malalaking kita at yaman, sila pa yung hindi nagbabayad ng buwis. Kasama na nga dito ang pamilya Marcos, kaya nga po may webinar tayo ngayon, na ilan na taon nang hindi nagbabayad ng kanilang estate tax, kahit sinisingil na sila ng BIR ng paulit-ulit. So this issue will be discussed in this morning's program entitled God Knows Who Does Not Pay, the 203 billion estate tax liability of the Marcoses. So ito po, sana po ay handa kayo dahil mainit po ang magiging talakayan natin lalo na't panahon ng kampanya para sa eleksyon na ito. So to give the opening remarks for our webinar this morning, we call on Professor Judy Tagiwalo, martial law survivor, former DSWD Secretary and convener of CARMMA. Prof. Judy, the floor is yours po.
Maraming salamat, Pat. Magandang umaga sa ating lahat. Good morning, Justice Carpio. Good morning, Sec Lim. And good morning to everyone in the Zoom room. I'm going to screen share as my opening remarks is basically introduction to CARMMA. Okay. Can you see my PowerPoint? Hello?
Yes, we can see it.
Yes.
Thank you.
Yes po.
So the campaign against the return of the Marcoses to Malacanang, that was the original name, and we added and martial law when Duterte declared martial law in Mindanao in 2017, or it was Quezon City, and we have several well-known anti-martial law personalities, Dr. Bien Lombera, VP Gingona, even Secretary Bello then. No, Ricky Lee, Pete Lacaba, among those who helped launch. The purpose was really initially to torpedo the vice presidential aspiration of Ferdinand Bongbong Marcos Jr. through public information and mass actions that hounded Marcos wherever he went. With the defeat of the Marcos Jr. in 2016 and the victory of Vice President Leni Robredo, CARMMA pressed on with its role as a campaign network, which reminded the public of the widespread human rights violations that were perpetrated by the Marcos dictatorship. Under President Duterte, the network led the broad campaign against the hero's burial, the dictator, at the libingan ng mga bayani. It filed a petition to the Supreme Court to nullify the Duterte directive to have him buried at the LNMB. It conducted information campaigns, advocacy, and mass actions, leading to the condemnation of the eventual burial of the former dictator in November 2016 at the libingan ng mga bayani. The network continued to lead advocacy and mass actions, especially during September 21, commemoration of the imposition of Marcos martial law, and in exposing and opposing the Duterte-Marcos alliance and Duterte's political rehabilitation of the Marcoses. This 2022 election, which comes during the 50th year commemorating the imposition of Marcos martial law, with the possibility of the restoration of the Marcoses to power and the extension of the Duterte's rule, have made CARMMA's advocacy take on an added urgency and significance. In its membership meeting last November 2021, CARMMA adopted the following thrust: frustrate the return of the Marcoses and Dutertes to the highest executive post, expose and oppose their fascist policies and anti-people governance, counter the various lies and disinformation by the two dynasties to evade accountability and towards their political rehabilitation and promote the people's vision for alternative governance. Since then, CARMMA has been the forefront of exposing the sins of the Marcoses in various arenas, mass actions, pickets, online rallies, and timely statements. The conveners were among those who filed the disqualification case against the Marcoses Jr. against Marcos Jr. with the COMELEC, which remains unresolved up to this day. Volunteer artists have made it possible for CARMMA to come out with popular forms such as comics and memes to highlight issues of corruption, tax evasion, and human rights violation of the Marcoses and Dutertes. We also conduct truth campaigns for communities, distributing leaflets and initiating discussions and voters' education. Recently, we have taken on the 2 billion property tax of the Marcoses, first revealed by Justice Antonio Carpio. We called for an online rally to denounce Marcos' non-payment of the tax women for action towards reform, launch an online petition asking the BIR to collect the taxes now. We are glad to have both Justice Carpio and former Tourism Secretary Nars Limobaware with us this morning to further clarify the what of the estate tax and why it is imperative that the BIR should demand payment from the Marcoses now. Maraming salamat, Justice Carpio and Secretary Lim, for joining us today. Let me end by sharing with you the people on the street interviews on the Marcos estate tax arrears made by CARMMA.
Magandang araw guys, ako si Sol. Tinanong ko ang ilan sa ating mga kababayan kung anong reaksyon nila sa 203.8 bilyong pisong estate tax na hanggang ngayon ay hindi pa rin binabayaran ng mga Marcos. Tara at pakinggan natin ang mga sagot nila. Magandang araw guys, ako si Sol. Tinanong ko ang ilan sa ating mga kababayan kung anong reaksyon nila sa 203.8 bilyong pisong estate tax na hanggang ngayon ay hindi pa rin binabayaran ng mga Marcos. Tara at pakinggan natin ang mga sagot nila.
Oh my God, nakaka-frustrate kasi tayo nagbabayad tayo ng tax natin. Sa totoo lang, sobrang pag nakikita ko yung payslip ko, parang sakit sa puso na ganun kalaki yung tax na kinakaltas sa akin. And then sila, nakakalaya sila dun sa obligasyon nila ng pagbabayad ng buwis. So, nakaka-frustrate.
Dapat babayaran dahil mayaman na nga sila, hindi pa nila babayaran. Kami nga mahirap nagbabayad ng tax eh.
Kung totoo po talagang may kinuha sila, mas maganda kung kailangan po kasi dapat may balik po talaga yan. Kasi pera po ng kaban ng bayan yan. Kailangan po talaga may balik sa atin yan para tulad ngayon na pandemic o nasa kalagitnaan tayo ng pandemya, mas kailangan kasi ng pondo ng government para masuportahan po tayo.
Ang masasabi ko lang ay dapat bayaran yon ng mga Marcoses bilang lahat tayo nagbabayad ng buwis responsibilidad nila yun na bayaran yon at lalong-lalo na yung mga ninakaw nila na yaman ng bansa natin. Kailangan ibalik nila yon sa atin.
Teka. Bakit naman ngayon lang lumalabas yan kung kailan eleksyon? Baka naman pinupolitika lang ang mga Marcos dahil tumatakbo si Junior. Oops, maghul.
Okay, thank you. Thank you very much.
Okay, thank
Back
you.
to you, Pat.
Thank you as well, Professor Judy, for that insightful introduction to CARMMA at sa kung ano nga po ang ginagawa ng CARMMA. So, mahalaga nga po na ating pigilan at kung bakit imperative nga sa mga pwesto sa ating gobyerno. So, kaya naman po ngayon, ang una nating tagapagsalita ngayong umaga ay para talakayin bakit dapat magbayad ng estate tax ang pamilya Marcos ay isang retired Associate Justice ng Supreme Court of the Philippines, si Honorable Justice Antonio Carpio. Magandang umaga po, Justice Carpio.
Thank you. Good morning to everyone. Thank you for inviting me to discuss with you the Marcos estate tax liability. Let me start with the facts and the law. The facts and the law are clearly stated in the final, executory, and unappealable resolution of the Third Division of the Supreme Court dated January 30, 1999. This resolution is a denial of the second motion for reconsideration of Ferdinand Marcos Jr. and Imelda Marcos involving the 23.3 billion estate tax assessment on the Marcos estate, the principal amount. The January 30, 1999 Supreme Court resolution concisely summarized the Marcos estate tax liability. This resolution narrated that in a decision dated November 29, 1994, the Court of Appeals dismissed the petition of Marcos Jr. questioning the 23.3 billion estate tax assessment issued by the BIR. The Court of Appeals ruled that since the tax assessment had become final and unappealable, and I'm quoting now the Court of Appeals, the manner and method in which the tax collection is sought to be enforced can no longer be questioned. And Marcos Jr. appealed the decision of the Court of Appeals to the Supreme Court. On June 5, 1997, the Third Division of the Supreme Court denied the appeal. And I'm quoting now from the decision of the Third Division. The Third Division affirmed in all respects the decision of the Court of Appeals, end of quote. The Supreme Court explained, and I quote, the subject tax assessments having become final, executory, and enforceable, the same can no longer be contested by means of a protest. Certiorari may not be used as a substitute for a lost appeal or remedy, end of quote. Now, Marcos filed a motion reconsideration. Imelda Marcos intervened and filed a motion to refer the matter to the Supreme Court en banc. On September 29, 1997, the Third Division of the Supreme Court denied the motion for reconsideration of Marcos Jr. and denied also the motion for intervention of Imelda Marcos for lack of merit. Still, Marcos Jr. and Imelda Marcos persisted and filed a second motion for reconsideration, which is actually a prohibited pleading. On January 13, 1999, the Third Division of the Supreme Court denied the second motion for reconsideration of both Marcos Jr. and Imelda Marcos. Now, the Supreme Court ruled in this January 13, 1999 resolution, and I quote, "We do not see any cogent or compelling reason to allow the same issues to be opened anew in the instant petition. As a settled rule, once a judgment or an order has become final, issues therein should be laid to rest. The court hereby denies the second motion for reconsideration of Ferdinand Marcos II and Imelda R. Marcos for lack of merit. This denial is final," end of quote. Let me repeat that. This denial is final. On March 9, 1999, the Supreme Court Third Division issued a resolution declaring the entry of judgment of the final decision, stating, "The Marcos estate tax assessment case," and I'm quoting now, "has on March 9, 1999, become final and executory." Let me repeat. The Marcos estate tax assessment, and I'm quoting now from that resolution, has on March 9, 1999 become final and executory, end of quote. Final and executory means the case is finished and terminated in the judicial department, and the decision must be forthwith implemented by the executive department of the government. Those are the facts and the law as clearly summarized by the Third Division of the Supreme Court in its January 13, 1999 resolution. Now, the Civil Code provides, and I quote, "Judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines," end of quote. The judicial decisions referred to here are the Supreme Court decisions. So the final and executory decision of the Supreme Court affirming the 23.3 billion Marcos estate tax assessment is now part of the legal system of the Philippines. It is now part of the law of the land. It is clear as day, beyond any shadow of doubt, that the estate tax assessment on the Marcos estate in the principal amount of 23.3 billion pesos had long become final, executory, and unappealable as of December 1991, when the Marcoses failed to protest the assessment within 30 days from receipt of assessment. That was 29 years ago. The decision of the Supreme Court affirming this estate tax assessment became final and executory on March 9, 1999, or almost 25 years ago. There are three separate and distinct dates here. First is the date when the estate tax return should have been filed and the estate tax should have been paid. This date is 6 months from the death of the decedent. So when a person dies, he has 6 months. The heirs have 6 months to file the estate tax return and pay the tax. The second date is the date of finality of the estate tax assessment. This date is 30 days after service of the notice of assessment on the heirs. So the BIR, after looking at the estate tax return, or if there is no estate tax return, will determine the tax and give you a notice of assessment. You have 30 days to protest. If you don't protest, it becomes final. That's the second date. And the third date is the finality of the Supreme Court decision. This is the date when the entry of judgment was made by the Supreme Court. This was March 9, 1999. So the estate tax assessment and the Supreme Court decision can no longer be questioned before any court. No court can overturn this estate tax assessment or the Supreme Court decision. Now, the principal amount is 23.3 billion. How did it balloon to over 203 billion? The interest on the estate tax start to run from the date the estate tax is due, which is 6 months after the death of the decedent. 6 months after the death of the decedent, the estate tax is due. And if you don't pay, the interest start to run. Ferdinand Marcos Sr. died on September 28, 1989. So the estate tax return should have been filed and the estate tax paid on March 28, 1999. That's the first date, March 28, 1999. The Marcoses didn't file the estate tax return on the date prescribed by law. And so the BIR commissioner prepared the estate tax return after investigation based on available public records. Since there was a deliberate refusal to file the estate tax return and pay the estate tax on the date prescribed by law, there is a penalty equivalent to 50% of the estate tax due. This is the 50% surcharge if you don't file the estate tax return and you don't pay the tax on time, 66 months after the date of death. There is a 50% penalty, 50% of the tax due. So it's added to the tax due. Also, there is a delinquency interest of 20% per annum imposed on the total amount due starting March 28, 1990, the date when the estate tax was due. Until December 31, 2017. Now, because the BIR commissioner had to investigate to file the estate tax return, there is also what is called a deficiency interest at 20% per annum based on the total tax due starting from the finality of the assessment, which was December 1991. And this ran until December 31, 2017. Why December 31, 2017? Because that is the old law. Under the old law, the interest rate on the delinquency interest and on the deficiency interest is 20% each, 20% for delinquency and 20% for deficiency. That was the law then, up to December 31, 2017. Because starting January 1, 2018, there was a new law under the train law. Starting January 1, 2018, under train law, the delinquency interest and deficiency interest have been reduced to a total of double the legal interest, or 12% per annum, since the legal interest is 6% per annum. So starting January 1, 2018, the maximum interest total is only 12% per annum. Now, based on the penalty and interest, the estate tax liability of the Marcos estate has now ballooned to more than 203 billion today because of the 20% deficiency interest, 20% delinquency interest from 1999 up to December 2017, plus the 12% interest per annum starting January 1, 2018. Now, the estate tax rate at the time of the death of Marcos Sr., he died on September 28, 1989, the estate tax rate at that time was 60% if the estate exceeded 3 million pesos. So it was very high at that time. Now, under the present law, Republic Act 10963, or under the Train Law, which took effect January 1, 2018, the estate tax is now a flat rate of 6% regardless of the value of the net estate. So now it is very low, 6% of the value of the estate. But this new estate tax has prospective application and cannot be made to apply retroactively to the Marcos estate. Thus, the Marcos estate is taxable at 60% of the net estate. Very high at that time, 60%. That's why it really ballooned. Now, Marcos Jr. and Imelda Marcos are the co-administrators of the estate Marcos, of the estate of Marcos Sr. Section 91D of the tax code provides, and I quote, "The estate tax imposed by Section 84 shall be paid by the executor or administrator before delivery to any beneficiary of his distributive share of the estate." So the estate tax is imposed, shall be paid by the administrator. Revenue Regulations number 12, 2018 and 17, 1993, implementing Section 91D of the tax code provides, and I quote, "The estate tax imposed under the National Internal Revenue Code shall be paid by the executor or administrator before delivery of the distributive share in the inheritance to any heir or beneficiary. Where there are two or more executors or administrators, all of them are severally liable for the payment of the tax." Severally means jointly liable for the payment of the tax. Now, this is the important thing. I'm quoting from the law, from the regulation. "The executor or administrator of an estate has the primary obligation to pay the estate tax, but the heir or beneficiary has subsidiary liability for the payment of that portion of the estate which is his distributive share, which his distributive share bears to the value of the total net estate." So the primary obligation to pay the estate tax is imposed on the administrator. There are two co-administrators of the Marcos estate, Imelda and Marcos Jr. And the other heirs are subsidiary liable to the extent of their share of the inheritance. Clearly, the tax code and its implementing regulation impose upon the administrator of the estate the primary obligation to pay the estate tax. Marcos Jr. and Imelda Marcos, as co-administrators, are legally and primarily mandated by law to pay the estate tax before any heir, including themselves, can receive a single centavo from the Marcos estate. Now, Section 255 of the tax code mandates, and I quote, "Any person required under this code or by the rules and regulations promulgated thereunder to pay any tax who willfully fails to pay such tax shall, in addition to other penalties provided by law, upon conviction thereof, be punished by a fine of not less than 10,000 pesos and shall suffer imprisonment of not less than 1 year, but not more than 10 years. So there is a criminal liability on the co-administrators if they do not pay the tax, if they willfully fail to pay such tax. In short, Marcos Jr. and Imelda Marcos can be charged criminally by the BIR and the DOJ under Section 255 of the tax code for willful refusal to pay the tax of the Marcos estate. The refusal to pay the estate tax is willful because almost a quarter of a century has passed since the decision on the estate tax case was declared final and executory by the Supreme Court. And still Marcos Jr. and Imelda Marcos have refused up to today to pay a single centavo of the estate tax. Now, the Marcoses cannot avail of the 6% estate tax rate under the estate tax amnesty. There was an estate tax amnesty last February 2019 under Republic Act 1123, 11.213, and the tax rate is only 6% of the net estate. But this could not be availed of by the Marcos estate because this law expressly states the estate tax amnesty under Title II of this act shall not extend to estate tax cases which shall have become final and executory. The Marcos estate tax case became final and executory on March 9, 1999, long before the estate tax amnesty was approved on February 14, 2019. So the Marcoses cannot avail of the estate tax amnesty. Now, the Marcos Jr. election campaign issued an official statement that the payment of the estate tax was suspended by virtue of an agreement with the BIR and PCGG to await the outcome of a case pending with the Sandigan Bayan. The BIR denied this. There is no such agreement to suspend the collection of the estate tax. In fact, the BIR announced that last December 2, 2021, the BIR sent another demand letter to Marcos Jr. and Imelda Marcos to pay the estate tax. And the PCGG also denied that there is an agreement to suspend the collection of the tax. The Marcos Jr. campaign statement that there is an agreement to suspend the payment of the tax is false, utterly false, and shows a willful refusal by Marcos Jr. to pay the estate tax. Besides, the Supreme Court decision affirming the estate tax assessment of the Marcos estate in the principal amount of 23.3 billion pesos can never be overturned by any decision of the Sandigan Bayan. In fact, the BIR and the PCGG both reaffirmed that the estate tax assessment on the Marcos estate had long become final, executory, and unappealable. But still, the Marcos election campaign keeps on repeating up to today that the estate tax case is still pending in court. Quote and unquote, is still pending in court. That's what the Marcos election campaign keeps on repeating. This is a blatant lie, which is clearly debunked by the Supreme Court resolution declaring that the decision on the estate tax case became final and executory on March 9, 1999, or almost a quarter of a century ago. In fact, the estate tax assessment, as distinguished for the estate tax case, became final and unappealable much earlier, 30 days after the estate tax assessments were served on the Marcoses from August to September 1991. Remember the 3 dates: the date when the tax became due, the date when the assessment became final, and the date when the decision became final. Thus, as of December 1, 1992, or almost 29 years ago, the estate tax assessment had already become final and unappealable. And this is the reckoning date for computing the 50% penalty and the 20% delinquency interest. The 20% deficiency interest is computed starting from the filing by the BIR Commissioner of the estate tax return after investigation. The decision of the estate tax case, as distinguished from the estate tax assessment, became final and executory on March 9, 1999. Now, there are those who claim that since 11 real properties of the Marcos spouses situated in Leyte were levied upon and auctioned off by the BIR in 1993 to satisfy the estate tax due, the government is deemed to have been fully paid already. That's what they're claiming. That's totally false. Section 217 of the tax code provides, and I quote, "The remedy by distraint of personal property and levy on realty may be repeated if necessary until the full amount due, including all expenses, is collected," end of quote. In other words, you keep on looking for personal and real property to auction off until the full amount is fully paid, until the 23.3 billion plus interest have been fully paid. Clearly, the proceeds of the personal and real properties auctioned off by the BIR must fully satisfy the entire amount of the tax due, including penalties and interest. The Marcoses never claimed that the proceeds of the 11 real properties that were auctioned off fully covered the entire 23.3 billion estate tax due. In 1993, the zonal value of these 11 real properties obviously could not have fully paid for the 23.3 billion estate tax due at that time. There are also those who claim that since ever ill-gotten assets are permanent imposed the estate tax, therefore these assets are legitimate, they're not ill-gotten anymore. In essence, the theory of these people is that payment of tax on stolen property legitimizes the theft, and the thief acquires legal ownership of the stolen property by virtue of paying tax on stolen property. This theory is, of course, morally, philosophically, and legally wrong and utterly reprehensible. First, the 10 Commandments state, "Thou shalt not steal." Full stop, period. It does not say that you can steal provided you pay tax on what you steal. Neither does it say that you can even become owner of the stolen property if you pay the tax on what you steal. Stealing can never be morally justified by paying a tax on what you steal. Second, philosophically and as a matter of public policy, no government or society can take the position that you can become the owner of what you steal if you pay tax on what you steal. A government that says you can become owner of what you steal if you pay tax on what you steal will make all government employees thieves, encouraging them to steal from government coffers, because by paying tax on what they steal from the government, they legitimize their thievery and become owners of what they steal. A government that adopts such a policy will end up with no money and will collapse. And no society can also afford to adopt such a policy, because every person will now steal from his neighbor and just pay tax on what he steals to become the legal owner of stolen property. Everyone in that society will be acquiring ownership. Under Article 712 of the Civil Code, the modes of acquiring ownership are occupation, intellectual creation, donation, testate and intestate succession, tradition as a consequence of certain contracts like sale, and prescription. Theft, even if you pay tax on what you steal, is not one of the legal modes of acquiring ownership under the law on modes of acquiring ownership. Prescription, which means possession of a thing for a period of time, may result in acquisition of ownership, but there are strict exceptions. Article 1133 of the Civil Code provides, movables possessed through a crime can never be acquired through prescription by the offender. Thus, a thief can never acquire lawful ownership of money or personal properties he has stolen, regardless of the passage of time. The thief can possess during his entire lifetime what he stole, but he can never acquire lawful ownership of the money or personal properties he stole. And if he is not the lawful owner of what he has stolen, he cannot transfer lawful ownership to his heirs. His heirs only acquire what he possessed, unlawful ownership of money or personal properties. And there is a special law, Republic Act number 1379, entitled An Act for the Forfeiture of Unlawfully Acquired Properties applicable to government officials and employees. Section 11 of this law provides, and I quote, the laws concerning acquisitive prescription and limitation of actions cannot be invoked by, nor shall they benefit the respondent in respect of any property unlawfully acquired by him. In short, ill-gotten assets or wealth by government officials and employees are not subject to acquisitive prescription. The ill-gotten assets or wealth by government officials and employees can never be owned lawfully by the official or employee, regardless of the passage of time. Finally, there is, of course, Section 15, Article 11 of the Constitution, which provides, and I quote, the right of the state to recover properties unlawfully acquired by public officials or employees from them or from their nominees or transferees shall not be barred by prescription, laches, or estoppel, end of quote. In short, the right of the state to recover ill-gotten wealth is imprescriptible. The state can recover ill-gotten wealth until the end of time. I will end my discussion here. Thank you for your kind attention and a pleasant day to everyone.
Maraming salamat po, Justice Carpio. So, ayun na nga po, so bale, ang original na presyo pala ng estate tax ng mga Marcos ay 23 billion at lumobo dahil hindi nila pinansin ng matagal at nagpatong-patong na ang mga interest at penalties. At sila nga po ay pwedeng makasuhan ng BIR at DOJ for willful refusal to pay of the Marcos estate taxes. So, isang paalala po para po sa ating mga kaibigan sa media na nais magtanong, mamaya sa ating Q&A portion, maaari niyo pong i-type ang inyong mga katanungan sa chat box o pakipindot po ang raise hand dito sa Zoom at bubuksan ng tech team namin ang inyong mikropono. At naman po, sa mga nabanggit ni Justice Carpio, may legal nga po na batayan kung bakit dapat singilin ng BIR ang pamilya Marcos sa mga utang nilang estate tax. Ang ating susunod na tagapagsalita ay tatalakayin naman ang online petition hinggil sa estate tax ng mga Marcos para mag-demand ng accountability ng pamilya hinggil dito. Siya po ay co-founder ng Alliance of Women for Action Towards Report o AWARE at dating secretary ng Department of Tourism. Kasama po natin ngayong umaga si Honorable Narzalina Lim. Magandang umaga po, former Secretary Lim.
Magandang umaga, Pat. Thank you to CARMMA for inviting me to talk about the Marcos estate tax liability. A little backgrounder lang po. I represent AWARE, the Alliance of Women for Action Towards Reform, which I co-founded in 1983, September 1983, right after Senator Benigno Aquino was assassinated. I co-founded it with Professor Winnie Monsod, Ambassador Ching Escaler, and 4 other women friends. We were outraged by that assassination, and we vowed that as concerned citizens, we would work very hard to end the Marcos dictatorship. I will not go into the many struggles that we went through, but we have been around for 38 years. Our numbers have dwindled. We have grown old, but we still have fire in our bellies. And as early as September 2021, we started fundraising for the campaign for the elections of May 2022. We launched a program called Let Women Lead. At that time, VP Lenny had not yet declared her candidacy, but we thought that we would urge more women to participate in the political exercise. So when she announced her candidacy October 7, 2021, AWARE was ready. We had some funds and we started campaigning immediately. Let Women Lead is also supporting the candidacies of Senator Leila de Lima and Senator Risa Ontiveros. I urge our audience to visit our Facebook page so that you will see what our advocacy is like. We believe that more women should participate, should be elected into political positions, and we believe that the next president of the Philippines should be a woman. So enough of AWARE, which is the organization that launched an online petition on March 20 in change.org, which is a social media platform. The letter was addressed to Commissioner Cesar Dulay as Commissioner of BIR, not just to collect and to send a demand letter to the Marcos co-administrators, but to file a criminal case against Ferdinand Marcos Jr. for failing to pay the estate tax, which, as Justice Carpio had mentioned, has ballooned to 203 billion. So we posted that petition online, and by March 29, we had gotten about 22,000 signatures. So we thought it was high time to send that petition to Commissioner Dulay. We requested for an appointment, but our request fell on deaf ears. Deadma talaga ang BIR. And so we printed a hard copy of the petition, and one of our members brought it to BIR. Hindi naman siya pinaakyat dun sa office ni Commissioner Dulay. So dun na lang sa baba, bumaba yung secretary at ni-receive March 30. So we have a hard copy that BIR received that petition. Now, what is interesting about this petition, as of yesterday, April 17, we have about 26,380 signatures. But what is interesting about the petition are the comments made by the signatories. Many of them feel very cheated because they are taxpayers who faithfully pay their taxes yearly, year in and year out. And today is the deadline again for filing our taxes. And they cheated that they pay while this family, the Marcoses, are handled with kid gloves. And it has been 25 years, maybe 29, and nothing has been collected from them. And as Justice Carpio mentioned, they willfully refuse to pay this tax. Okay, so people are saying, how can we elect as president someone who is a tax evader or who has broken the law? Okay, I urge you to go to the change.org website and read the comments, and you will see how angry people are. So people ask me, so what has been the effect? Because BIR has not even responded to you. Well, for me, it's awareness raising. There are now 26,000 people plus angry people and their relatives and their respective networks who will surely not vote for Ferdinand Marcos Jr. because he does not deserve to be president of this country. And we can use this, continue to use this in the last 20 days of the campaign as a big issue for why not to vote for Bongbong. So where do we go from here? One, I think we have to fill up the streets on April 23. Ironically, that big rally that is being called on the birthday of VP Lenny is going to be at the Diosdado Macapagal Avenue. I find that really ironic because of GMA's participation with Bongbong in this, in all the shenanigans leading up to this election. But anyway, we have to fill up the streets. We have our placards have to keep repeating this unpaid tax liability. And last March, thousands of artists held a concert in Quezon City Circle. I hope some of them are listening here. They launched the Bayad Buwis movement. They're very angry because artists and performers pay high taxes and they're harassed by the BIR if they don't do so. So maybe we could all team up together and to continue making this a big issue until the end of the campaign. So let's move on. Thank you for your time and attention.
Maraming salamat po, former Secretary Lim. So ayun nga po, tulad nung sa video na pinlay ni Prof. Judy Tagiwalo kanina, mga comments sa petition ay the people feel cheated dahil nga sila ay nagbabayad ng buwis. Pero ang mga Marcos na sobrang yaman ay hindi nagbabayad. At ayun nga po, nire-reiterate ko na where do we go from here? At tayo po ay let's fill in the streets at at lumabas sa lansangan at kumatok sa mga bahay-bahay, ano? At lalo na po sa April 23, yung nabanggit po ni former Secretary Lim na big rally para sa kaarawan ni VP Lenny. So, muli po, maraming salamat po kay former Secretary Lim at kay Justice Carpio sa pagpapa-unlock ninyo sa programang ito. So, live po tayo ngayon, ano, sa mga FB pages at YouTube channels ng CARMMA. At cross-posted tayo sa mga FB pages ng marami pang mga organisasyon. Mayroon po tayong mga kasama sa media ngayon sa ating Zoom room na nais magtanong. Para po sa mga kaibigan nating journalists, maaari nyo pong itype ang inyong mga tanong o mag-raise ng hand para ma-open po ng ating tech team ang inyong mga mikropono. We are now moving on to our question and answer portion po. So kung may mga katanungan po kayo, pwede nyo pong i-chat or pwede po kayong mag-raise hands. Okay po, sinandin po ni former Seclim yung change.org petition. Pwede nyo pong basahin. At meron po tayong katanungan. So this is directed to Justice Carpio and Seclim. So any reaction po on the statements of Juan Ponce Enrile? Juan Ponce Enrile said any tax liabilities that the Marcos estate now faces cannot be passed on to Marcos, especially since most of them are still being heard in the Court of Appeals and the Supreme Court. He also said that before the Bureau of Internal Revenue can charge Marcos Jr. and his mother, former First Lady Imelda Marcos, as administrators of the family estate, the case must first be settled in court. So ayun po ang katanungan ay ano po ang reaction ninyo sa statement ni Juan Ponce Enrile?
Well, Enrile already stated that the estate tax assessment has become final and executory. Inamin niya na. Pero sabi niya, yung Supreme Court nagbabago yan, baka magbago pa sila. Well, alam mo, speculation yan. When he admitted that the estate tax assessment has become final and executory, the consequence is bayaran na. Because final and executory, inamin niya na final and executory. Therefore, bayaran na. Hindi, you cannot say, baka magpalit ang isip ng Supreme Court 20 years from now. Hindi pwede. Abogado siya eh. Pag inamin niya final and executory, that means sabihin niya na bayaran na kasi final and executory na. Ngayon, sabi na hindi raw liable yung mga heirs, klaro nakalagay sa batas eh. They are liable if there is a willful refusal to pay the estate tax. Nakalagay pa sa regulations. They will be liable. The co-administrators are primarily liable. They have the primary obligation to pay the tax. And the other heirs have the subsidiary liability. Klarong-klaro yan eh. Nakalagay doon, black and white eh. Sabihin mo na hindi liable eh. Nakalagay doon liable eh. Thank you.
Former Seclim, any reactions po?
I agree with Justice Carpio. He's more of the expert on the law.
Okay po. So, Prof. Judy, you were raising your hand po kanina.
Yeah.
Yes po. Okay.
Yeah, I want to ask Justice Carpio, if, heaven forbid, Marcos win, what can he as a sitting president do to eliminate his family's legal, criminal, and tax liabilities?
Well, the estate tax liability has to be renewed every 5 years. In other words, BIR must file a written demand every 5 years. Otherwise, it will prescribe. Prescribe means the right of the state to collect lapses. So he is president for 6 years, BIR commissioner. So the reason why all these years, the BIR examiners have not been pressing this tax assessment against the Marcoses because they are elected officials. They're senators, congressmen, and governors. Takot. how much more kung presidente siya? So, if he is president for 6 years, 5 years yung prescriptive period, wala na yun. The right to collect by the government will expire.
Wow.
Yun ang problema. Because we've already seen it. Takot ang BIR examiner to go after the senator. He is a senator, the sister is a senator, he is a congressman. Lalo na kung presidente yan, wala nang mangyari dyan. Thank you.
Wow. Wow. Thank you.
Thank you po. Thank you po, Prof. Judy and Justice Carpio, for that very insightful comment, ano? And then for our friends from the media, kung may mga katanungan lang po, ayun, again, mag-chat lang po or mag-raise po kayo ng hand para kayo po ay mapaunlakan ng ating tech team. Ayun po, I am encouraging our friends from the media to ask questions for Justice Carpio, former SecLim, and to Prof. Judy Tagualo. Okay po, so our third question po is directed to former Secretary Lim. So what are your plans po in holding the Marcoses liable in their non-payment of estate taxes?
Well, since BIR has not responded to us, we just have to continue the pressure in terms of forums like this, placards, I said, during the rally, and teaming up with other groups, as I mentioned, like CARMMA and Bayad Buwis movement, to keep up the pressure and raise the awareness during the house-to-house campaigns about this issue. It's not only the estate tax, but the fact that Marcos is a convicted criminal for not paying his income tax when he was governor of Ilocos. I think that should also be brought out.
Okay po. Maraming salamat po. So, may isa pong katanungan galing sa okay po. Okay, so this will be the last question daw po for this question and answer portion. So may nagtatanong po sa galing sa ating mga manonood. So what can citizens like us do, and can we file criminal cases versus the Marcoses on this issue? I think this is directed to everyone po ata. So what can the citizens do? And can we file criminal cases versus the Marcoses on this issue? Ayan, Sec Carpio. ST Carpio po.
Okay. Two things. The citizens have the power in their hands by not electing Bongbong Marcos. That's the first thing. We have the power to stop him, because if he becomes president, he will allow this right of the state to collect the tax to lapse, to prescribe. So it is in our hands to stop him by not voting for him, electing him. Second, we can file a case against the BIR officials because there is a provision in the tax code. In case BIR officials, in case they are negligent in doing their duty, and that negligence allows somebody to violate the law. By violate the law means a taxpayer is freed from liability because the prescriptive period lapsed. If the prescriptive period lapses because of the negligence of the BIR official, they can be liable. So if they allow this to lapse, we can sue them for negligence. That's a crime under the tax code. So two things. And the most important thing is we have the power to stop. And that's 2 weeks from now, less than 3 weeks from now, we can decide. The nation can decide. We have the power in our hands. Thank you.
Thank you po, Justice Carpio, for that. So tama nga naman po na nasa atin ang kapangyarihan ngayong eleksyon, kaya importante na huwag piliin ika nga po nila, magpiliin ng tax evader. So now naman po, I'm calling Miss Regine Cobato from Washington Post. I think she has a question for you po.
Hello everyone. Thank you to the speakers and the organizers for this presser. Just in relation to Justice Carpio's previous comment, I wanted to ask: are there any solid plans or considerations on your part or on the part of CARMMA or Aware to take action and possibly file cases against these BIR officials if they still choose to ignore the petition and ignore calls to really act on the cases against the Marcoses?
Well, let me answer that. Well, we can file the criminal case if they allow the prescriptive period to lapse. It has not yet lapsed now, as far as the BR is saying, because they filed a written demand last December 2, 2021. So I'm assuming that that is within the 5 years from the last demand letter. So we are just reminding the BIR officials that there is this law that they can be held liable. So but that is a right that we can do later on if it is determined that the prescriptive period have actually lapsed, and we can easily determine who are the responsible BIR officials during that time. Thank you.
Okay, I see. So to be clear, it's an action that can be taken around 4 years from now if there is no action still by then.
Well, it can be taken the moment we find out that the 5-year period has lapsed. Remember, they just filed it December 2, 2021. But I do not know if that is within the 5-year period, the last demand letter, because we do not know when the last demand letter was made prior to December 2, 2021. If it is within the 5-year period, then there's no problem. But supposing this December 2, 2021 letter was already late, it was more than 5 years. The moment we find out, then we can file already a criminal case. Thank you.
Okay, thank you.
Former Seclim, do you want to add some insights po, or if there are any plans from Aware in light of what Justice Carpio just said?
Well, we will certainly consider it, but we hope that we will need help to find out whether the December demand letter fell within the 5-year period. We will need help with that because, BIR is not accessible. They're opaque. So if there are insiders who can help us, we would appreciate it. We haven't even seen a copy of that demand letter. I don't know if it really exists. That's just what BIR said in their letter to Acción Democrático when they wrote asking. And they said yes, but they did not attach a copy of the letter. So, totoo ba yan? We don't know. These people just keep running circles around us as if we were so stupid. So, yeah, a little more detective work maybe will help. And then we can plan from there.
Okay. Thank you po. Okay. Thank you so much, Seclim. So we have maybe this will be the last question from June Bautista. So do we know where the tax assessment was based? Yun po yung tanong. So do we know where the tax assessment was based?
Well, the Marcoses did not file the estate tax return. So under the tax code, the BIR commissioner will file. And that's exactly what they did. They based it on public records, based on the claim of the Marcoses that they own so much property. I have not seen exactly the properties that were included, but the Supreme Court said it's now immaterial how it was computed, what was the basis, because they failed to protest on time. It's now immaterial. Remember, Imelda said we own practically the entire Philippines, and they had so much Swiss account deposits. They said we own that those deposits. The Marcoses claimed it in the Sandigan Bayan. They filed a pleading that it is part of the estate of a Marcos Sr. Thank you.
Thank you po. Thank you very much, Justice Carpio. So, Prof. Judy, you were raising your hand po kanina. Sorry na, you are muted po.
I was just going to ask another. How come it has taken this long for us to demand payment? And how come we cannot complain against the BIR for their failure to have these taxes paid? Because as Justice Carpio said, the Supreme Court declared it final and executory almost a quarter of a century ago.
I think we should ask the BIR commissioners at the time, no? After 1999, why they didn't move to collect the tax. I mean, they kept on writing demand letters to preserve the right, but they did not actually go after the properties. You know, the Marcoses, I think they live in, they have houses in condominiums here. They shouldn't be able to acquire properties without paying the estate tax, because the law says after the death of a person, death of Marcos, none of his properties can be inherited unless the estate tax is first paid. They cannot get a single centavo, the heirs cannot get a single centavo to buy any property, to put in their name, unless the estate tax is paid. So where did they get the money to campaign, to run political campaigns, to live abroad? And are these houses that they are living in, are these houses in their name? Because they cannot put any property in their name unless they have paid the tax, because the estate tax must first be paid.
Okay.
Thank you.
Okay. Thank you.
Okay. Maraming salamat po. So, last call po kung may mga katanungan pa. Siguro po mag-aantay ako ng mga siguro additional 3 seconds for that. And so far wala pa naman pong nagtatanong ulit. So ayun po, kung wala na pong mga katanungan, sad to say, dito na po magtatapos ang ating programa na God knows who does not pay the 203 billion estate tax liability of the Marcoses. So maraming salamat po sa ating panelists, Justice Carpio, Sec Lim, and Prof. Judy Tagiwalo para sa pagpapaunlak sa event na to. At maraming salamat din po sa ating mga kaibigan galing sa media. At maraming salamat po sa lahat ng nanood sa FB Live, sa YouTube at sa lahat ng pages na cross-posted ang event na ito. Sana po ay magkaroon kayo ng magandang tanghali at masarap ang unan ninyong lahat. Bye-bye.